webinar that is tagged CAMA 2020 and the right to freedom of religion/association is proudly brought to you by the Nigerian Bar Association, Garki Branch, Abuja. I can assure you that at the end of this webinar, you would have been kept apprised of the principles, the facts, and the decision of the judgment of courts in respect of some sections of CAMA that affect civil society organizations, non-governmental organizations, and registered trustees, basically. Aside this, we would also have understood the rationale behind the court judgment, as well as the implications of this judgment on the compliance ecosystem in Nigeria. So I would want you to sit back and relax as this webinar goes on. Now, going forward, I would like to establish the ground rules for this webinar. So presently, I can see that almost everybody is muted. That is beautiful, because one of the ground rules for this webinar is that you kindly mute your microphones. Please mute your microphones. We don't want any background sound interfering with the presentations and the conversations that will ensue hereafter. So thank you very much for muting your mics. Also, I would like you to turn off your video while the presentations are going on for now. However, at the end of this webinar or towards the end, would require you to turn on your video. That's if you can. So we take a group photograph and save this memory as a beautiful time where we deliberated on this judgment of court. Also, I would like you to know that there is going to be a Q&A session after the presentation for you to ask your questions, but that should not stop you from typing in your questions in the chat box spontaneously. As it hits your head, as it comes to you, you need to type that question in the chat box as the presentation is going on. And certainly, our beloved guest speaker is going to take your question as they drop on the chat box. So feel free to drop your questions on the chat box even before the Q&A session. To welcome you once again, I'll give you a drum roll and a virtual round of applause to everyone joining us from different parts of Nigeria. Welcome, welcome, welcome. Ladies and gentlemen, with a virtual round of applause, you can use the clap hand icon. There's an icon, a clap hand icon. I would like you to join me as we make welcome for the opening remarks, none other than our distinguished, delectable, innovative, and pragmatic chairman, Mr. Obioma Ezewombodo.
Okay, good morning. Good morning, all. Welcome to today's webinar. The essence of the webinar is to talk on germane issues, contemporary issues, and today's issue revolves around the CAMA. We all know that the Federal High Court the other day notified some sections of CAMA on the basis that they are against fundamental human rights of citizens. So we deem it fit to talk on it today, to periscope it and to understand it better, because any issue dealing with fundamental human rights of citizens are very essential and we shouldn't take them lightly. So that's the essence of today's webinar. And thank you, Princess Obare, for bringing this issue up and bringing the program to fruition. Thank you to our special guest. I don't know whether he's part of us now, but I believe he will join us soon if he's not. Thank you, everybody, for making our time to be with us here today. Thank you.
Thank you, Mr. Chairman, for that succinct, straight to the point, and yet powerful opening remark. The remark was just short enough to keep us wanting more, long enough to cover what we need to hear for today. It was just succinct. Thank you very much, sir. Thank you. Okay, so quickly, as the chairman laid the foundation, he talked about the fact that some sections of CAMA were struck out. That only happened because one man decided to challenge these sections of CAMA in court. And who is this man we're talking about? Permit me to read his profile to you because I have to read it out. It's quite a lot. So let me read his profile to you. Mr. Emmanuel is the managing partner of Fred Young and Evans LP, a full-service commercial law firm in Nigeria, and also Fred Young Recoveries, an international debt recovery firm. He is a fellow of the Chartered Institute of Arbitrators, England, Nigerian branch, and also a fellow of the Nigerian Institute of Management Consultants. He holds an LLM in International Business Law from the University of Liverpool, England, in 2021. He's experienced in recovery of diverse debts across borders. He has been engaged in prominent public interest litigations, like the suit on the constitutionality of the excess crude accounts. He has been counsel in important international commercial arbitrations and a leading light on registration and enforcement of intellectual property rights in Nigeria. Emmanuel has authored several papers and scholarly articles, including Challenges and Prospects in Enforcing Fundamental Human Rights in Nigeria, Arbitration, a bane to prompt resolution of international commercial disputes, a case of Nigeria, impact of Nigeria's legislations and business practices on foreign investments and enforcement of arbitral awards and foreign judgments in Nigeria, among a host of others. Ladies and gentlemen, I would like you to join me to make welcome none other than our dynamic speaker for today, Mr. Emmanuel Ekpenyong. Please put your hands together for him. A virtual round of applause would suffice. Thank you so much. Mr. Emmanuel, please confirm you are with us and you can hear us.
Yes, I'm with you. Can you hear me?
Yes, we can hear you clearly.
Okay. Yes.
We can hear you clearly. Thank you very much.
It's actually a privilege to be here. I know the chairman, I don't know whether he will know me, but it's a privilege for the whole of MBA to actually invite you to speak on a very topical issues like this. So I'm very honored. And Princess, thank you too for following up to get me here. I'm very grateful.
Thank you for honoring our invitation, notwithstanding the length of the notice. Thank you for accommodating us. So we'll take it away straight up. And the first question I would like to ask you is, please, I would like to reiterate the ground rules before I ask him the question. Don't forget to keep your mics muted so there is no interference with this presentation and discussion. Thank you. Okay, so the first question I would like to ask you is, what prompted you to file this action against the National Assembly and the Corporate Affairs Commission, among other defendants and judgment debtors? What prompted the action? Thank you. Okay.
Thank you very much. I've always been, growing up in Kaduna, I've always been interested in fundamental human rights. So that is the main reason why I became a lawyer. So when I studied in Zaria, I studied law in Zaria, Ahmad Bello University Zaria. I wrote my project on challenges and prospects in enforcing fundamental rights in Nigeria. I now got to know about so much of the human rights abuses in Nigeria that even most of the law enforcement agents and even the government itself do not understand the extent of the fundamental human rights. Now, the fundamental human right is the basis upon which every country is founded. Now, before 1945, fundamental rights was based on culture, belonging to a certain group of people, And, that is where you have a right. Now, it was after the Second World War in 1945, when the United Nations was formed, that it was now a topical issue. Let us know the rights that are inalienable to every human being. What are these rights? It doesn't have to belong to anywhere. Once he is born, this right follows the person. So in 1948, the Declaration of Human Rights was now passed, and it was adopted by 56 countries. And since then, every country of the world have it in one way or the other in its constitution. It is not a mistake that it is in the constitution of most of the countries. Even in successive constitution in Nigeria, the fundamental right has always been in the constitution. Now, it is in the constitution because the constitution is the grand norm of any country. Now, fundamental right ought to be the basis upon which every other law is made. Not, the laws are not supposed the fundamental rights are not supposed to be subject to the law. The law ought to be subject to the fundamental right. So when they passed the new CAMA, beautiful law. As we go ahead, I will tell you so many things. I do a lot of company law practice. I do a lot of company secretariat work. The CAMA is a very beautiful law. Don't get me wrong. But it is when it now got to incorporated trustee that the operation of those sections that we actually challenge in court, if those sections are actually implemented, it will take away the fundamental, it will go a long way to take away the fundamental rights of Nigerian citizens. And it will create chaos. It will create problems, being the kind of country that we are a religious people. And I said, instead of just discussing it on the pages of newspaper or when we gather to speak, why not take it up and explain it to the court that these laws are capable of throwing the Nigerian nation into chaos? Because as we tend to analyze, if somebody who is not a member of a religion or is not a member of an association can have power to remove the incorporated trustee, the head of, for instance, a movement or a religious sect, you are causing problem in which it will cause problem in the society. So this is what motivated us. 2020, it was before Justice Taiwo, and Justice Taiwo retired. But since we believe in this course of action, we had to follow it to a conclusion in which judgment was now delivered. And thankfully, it was delivered in our favor on the 18th day of April, 2023.
Oh, wow. What passion. What passion. Wow. Just from the little you've said, I can see the passion burning for the issues of fundamental rights in Nigeria, and actually the need to make sure that these rights are rights that we enjoy as citizens, regardless of the benefit that will come to you or not. Thank you so much. So moving forward, I have the judgment on the screen. So this is discussion proper. For a lot of people that have not heard about this judgment, can you please just tell us the facts of this case? Because you're the plaintiff in the case.
Yes, thank you. So basically, it's a simple and straightforward case. We commenced the action by an originating summons in which we sued the National Assembly because by our law, Section 4, they are the ones that make the law. They are the ones to implement this law. And they are the main one in which the law is being implemented, that will implement it. The office is the chief law officer of the Federation, in which he knows, or he ought to know, that this law should not go against the fundamental rights. That is why it's still different from the Minister of Justice. I don't think this, because we do not think.
Sorry, sir, to interrupt. You may need to turn your mic with you when you're turning your face, because when you turn your face, we don't hear you anymore.
Very well. I won't turn my face again so that you can hear me.
No, please feel free. Thank you.
Yes, please. I said the National Assembly because they made the law, PSC because the law was made to their benefit, in which they will be the one to execute the law, and the Attorney General and Minister of Justice because he is the chief law officer of the Federation, in which this also reinforces my argument, the argument that have been in the public space, that the office of the Attorney General should be different from that of the Minister of Justice. Because the Attorney General, if it was different from the Minister of Justice and not in the cabinet of the President, ought to know that this law, this section of the law ought not to have seen the light of the day. So we commenced the action by an originating 31st day of August 2021, in which we asked the court to determine whether those sections, the sections in which it gives CAC the powers to remove incorporated trustees when he reasonably believes, which is subjective or even sentimental. They can remove if they think that incorporated trustees are not being managed well, or if they are managed fraudulently, they on their own can remove the trustees of incorporated trustee and appoint interim managers. Now, no criteria was given on who these interim managers will be. Will they be also members of the association? Not. So this gives the CSA a wide latitude to appoint anybody. They can appoint anybody to be an interim manager. Now, it now went ahead to say that CSE, that if an association have one or more accounts, the bank have to tell CSE about this account. And if there is a dormant account, within 15 days, the bank have to tell CSE. Now, our question, as we'll see in the judgment, what is the business of CSE with the account of association? It is not state fund, it's not public funds. It is people, for instance, if, for instance, I'm an Ibibio man and Ibibio people gather and contribute money, what is the business of the state or CSE with the money that we contributed for the welfare of, for instance, our children? You are actually leaving state matters and going into private matters. That's what we think. And that the association should also file biannual reports. Now you are making it, as the court said, you are making it look as if they are incorporated companies. They are making it look as if they are incorporated companies. But the main one that also got me really agitated was Section 851 that, established the Administrative Proceedings Committee, which now took over the powers of the Federal High Court under Section 251E, that says every matter that flows from CAMA will go to the Federal High Court. They actually established that committee, in which the registrar of CSE will be the chairman of that committee, and directors from CSE and Ministry of Trade and Investment. Now, most of the cases on CAMA, CSE is either the main party or a nominal party. How can you, by that section of the law, be a judge in your own case, in which it is against natural justice and against Section 6, subsection 6, that also gives us a right to access to court? It gives every person, not just a citizen, every person in Nigeria have a right to access to court, and as well as Section 36(1) of the 1999 Constitution that talks about fair hearing, that you have a right for your case to be determined before an impartial judge in which your matter ought to be heard. So we actually believe that this right, this provision of the law, wants to take over the right of access to court of not only EMMANUEL EKPENYONG, but most of Nigerians. And if the state can now take over through, of course, CSE is the executive, part of the executive arm of government. If the state can, through that law, take away the right of citizens to approach the court to determine matters that even concern the state themselves, then are we not going back to the military era? Even in the military era, some of these things, this kind of Draculan law was not there. So this is what prompted us to commence this action and ask the court to interpret whether this section does not run in the face of Section 38 of the Constitution, provides that every person, not every citizen, every person has a freedom of conscience, thoughts, and religion. And this is also reinforced by the African Charter of Human and People's Rights, Ratification and Enforcement Act. Article 8 actually provides that everybody has a right to profess their own religion and consciousness, and that the state should not take any right to restrict this right. And this is what the law in CAMA is actually doing, to try to restrict this right. Because if you appoint somebody who is not a member of, for instance, my religious sect or a movement in which I belong to, or a civil society I belong to, you are actually infringing of my right to my conscience. And also Section 40 of the Constitution that provides for freedom of association, in which also Article 10 of the African Charter, actually, which has been domesticated and is an act of the National Assembly in Nigeria, actually, provides that these are the rights that are inalienable to every human being. So the CAMA ought to have, in making that law, the National Assembly ought to have considered these demand provisions and the far-reaching effect before making the law. So since that was, maybe it's an oversight, that is why we had to bring it before the court, for the court to look at it also and, determine to what extent, those sections are our fundamental.
Okay, thank you so much, sir. Very pertinent issues. There's one question that I have concerning this issue, but I won't ask it now because for the benefit of those that are following, especially those who don't have a copy of the judgment who have not read it, I would like us to take these sections one after the other and then talk about the rationale of the court in striking out the sections. So the first section I have on the screen is section 839 of the Companies and Allied Matters Act 2020. And that is a section that can everyone confirm that they can see the screen?
Yes, we can see it.
Okay, thank you, that's fine. It's okay. So this is a section that empowers the commission to suspend trustees of an association and appoint an interim manager or managers to manage the affairs of an association where it reasonably believes that there has been any misconduct from its management in the administration of the association, or where it thinks that it is necessary or desirable for the purpose of protecting the property of the association or securing a proper application for the property of the association towards achieving the objects of the association, the purposes of the association, of that property, or the property coming to the association, or where he believes that it is in public interest, or that the affairs of the association are being run fraudulently. It goes further to say that the trustees shall be suspended by an order of court upon the petition of the commission or members consisting 1/5 of the association. And then upon the hearing of the petition and the appointment of the interim manager, the court, with the assistance of the commission, will make provisions with respect to the functions to be performed by the interim manager or managers. So, yes, my question here is, if you have any question, don't forget that you can put your question in the chat box as this presentation is going on. My question here is that, how does this provision infringe the right to freedom of association? How does it infringe the, considering that before CAC can suspend the trustees, they will actually need to obtain a court order, and that court order, I'm not sure, is one that will be an ex parte order. The association to be affected will definitely be put on notice. So how does this section seems to infringe on the right to the right to freedom of association and religion? In your opinion and the rationale of the courts. Thank you.
Very well. Very well. As a background, let's not forget that Section 827 of this same Companies and Allied Matters Act provides that every association will have a constitution, and the constitution will provide the aims and objectives of the association, make provisions in respect for appointments, powers, duties, tenure, replacement of trustees. Now, the same constitution will make provisions for the use, the custody of the seal, and the meeting of the association, the number of trustees, how they can be removed, and how the funds belonging to the association will be used, and how the accounts of the association will be managed. Now, the provisions, the law is already, the powers have already been given to members of that association to manage how they want the association to be. Now, do you know the number of associations we have in Nigeria that CSE will leave management of companies to now come and be looking at how cultural affairs are being managed? Meanwhile, they have members. Any member that do not like the way in which the association is managed have a right under Section 36 of the Constitution to actually go to court and argue his case out. It is not CSE's business, to my humble opinion, to want to know that my business, my association, or where I profess my religion is not being managed well. It is me. You are not a member of my association or my NGO. It is me that feel it. It is me that knows. Do you understand? Number one, it is, CSE going to a business that does not concern him. And two, CSE, you are not a member of such a place. So why do you want to use by law and go to a place so that CSE will not make law one day, or the National Assembly will not make law one day, for the state to determine what happened in my personal property or what happens in my personal house? So if you see, he said the trustees shall be suspended by an order of court upon the petition of the commission or members. It is not CSE reason to petition. That is my point. My point is that it is the prerogative of the members of that association, if there is any problem, to go to court. Because, for instance, as we said, for instance, I am a Catholic. Now, there is a reason why I choose Catholicism above any other form of denomination. If, for instance, I contribute money and I do not like the way the incorporated trustee of the Roman Catholic Church is running it, it is my business. It is my fundamental right to go to court to ventilate it. It is not the duty of the commission, because the commission did not give me money to actually do the contribution. Neither is the commission a member of the Roman Catholic Church. So there should be the only way that the state should interfere is if, for instance, for public order. And as the court rightly said, there is nothing against public order in what CSE is doing. There is nothing against, if the members of a certain group of people or a certain set have a problem in the way that incorporated trustee are being managed, they should be the one to go to court. So the problem I have with Section 839 is giving CSE any form of power to appoint an interim manager. And the interim manager, for instance, in the case I said, the Roman Catholic Church, may be a Pentecostal person, maybe an atheist, maybe any other person. And if they appoint that person to come and be my trustee, because the interim manager will have the powers of a trustee. So if you appoint such a person to come and be, have you not taken away my right? Now that person does not profess my faith. He do not understand what we do there. What if he comes and wants us take us to another direction? That is not the fundamental principle of the state, of the association. So in this way, you've also infringed on the right of consciousness, as well as the right to religion and association in such an instance. That is how I see it. And the court at first instance actually agreed with us.
Exactly, the court agreed with you totally. Wow, I hope I'm following this discourse. So the takeaway from this is that, first of all, it is not the prerogative of the members of CSE. It's not the prerogative of CSE to complain if funds are being mismanaged or to suspend trustees, but rather it is the prerogative of the members, because they're actually the ones to make the donations, make the contributions, and they're actually the ones who are affected. The trustees make on one hand, and on the other hand, there's the likelihood that the interim with people of like faith or like mind to run the affairs of the association. Okay, I have a question there, but I'll come back to it in the Q&A session. Going questions in the chat box. So we've heard what the section provides, 839. We've also heard the opinion of the plaintiff, what he submitted in court, and how the court agreed with him, and the court rationale for making this decision. I'll be moving on to the next section, and that's section 842. Section 842 is a section that talks about bank accounts for trustees, incorporated trustees. It says where a bank holds one or more accounts in the name of, on behalf of incorporated trustees of a particular association, and the account, or if it holds two or more accounts and each of the accounts is dormant. So where the bank account of an incorporated trustee is dormant, and then the commission is notified that the bank, this trustee, this registered trustee or incorporated trustee has a dormant account. Whenever CSC is notified of that, they may request that the association should provide evidence of their activities. And if the association fails to respond satisfactorily within 15 days of the request, CSC will dissolve the association in accordance with section 850. When it says in accordance with section 850, it means, dissolution of association, going to court and all of that, setting up the dissolution process in court to dissolve the association. And when it does that, any amount that is standing to the credit of the association in their account CSC is going to, I know that CSC is going to amount, or as the case may be, the aggregate amount signed to the credit of relevant association in the account or account in question. CSC will transfer it to another association, or to each of two or more other associations so specified in the direction, such part of the amount or aggregate amount as is there specified in relation to that association. So CSC has the power to, after taking them to court, to dissolve them, you have to transfer the money to other associations. And then 843 says where any bank has given notice to CSC for a dormant bank account, the bank shall not reactivate the dormant account without first notifying CSC. So except CSC is notified, the account cannot be reactivated. And then if before any transfer is made by the bank in pursuance of a direction under section 842, the bank has cause to believe that the account or accounts held by it in the name of or on behalf of an association is no longer dormant, the bank shall without delay notify CSC that the account has ceased to be dormant. And if it appears to CSC that the account is no longer dormant, or where CSC receives a satisfactory account of the activities of the association, it will revoke any direction it made to the bank concerning the issue of dormancy. So 844 also talks about the issue of dormancy and talks about the fact that there is no need to be secretive about it, no obligation as to secrecy or other restriction on disclosure. You understand the relationship between a bank and customer. So that duty of confidentiality, this is an exception to that duty of confidentiality going by this section. And however, dormant bank accounts imposed shall preclude a relevant bank account from disclosing any information on supplementary the status of dormant bank account to the commission. So this section is just all about a trustee, an incorporated trustee having a dormant bank account. Yeah. So I would like to ask Mr. Speaker, sir, how on your right on the right to freedom of association or religion, and also when you talk to me about it, you're going to tell me in the light you argued in court, and then the rationale, what the court said in agreeing with you to strike out this section, because what I can see here is that this section is one to help put organizations on their toes. So you don't just have an organization and open an account and nothing is happening. You don't just have anything happening and the organization is just there existing, no returns have been filed, nothing is being filed and nothing is happening. So I think just to make sure that it's only associations that are serious, wanting to be going concerned, so where they stop being going concerned, you take the necessary step to dissolve the association. That is what CSC is trying to check me. From my opinion, in my mindset. I don't know if any other person sees it that way. So please tell us. Just tell us.
Okay, now there should be, I understand, in any sane society, there should be ways in which the state will checkmate, improper practice as well as fraud. For instance, some of them. Hello?
Sorry to interrupt. Sorry to interrupt. Someone is complaining about the audio. Is it clear now? Can anyone confirm that you can hear us and hear us well?
Very well, very well.
Okay.
Very well at our nature here, Anambra State. Very clear.
That's and please go on, Mr. Speaker.
Understand that in any system, they should monitor funds. I'm very knowledgeable about that. So, for instance, to prevent money laundering and other financial crimes. Now, but there should be an extent. You should not, for instance, monitor, to prevent financial crimes to the extent of infringing on the right to privacy as well as the fundamental rights of people. So there need to be a balance. So, Princess, I want you to understand that what I'm saying is that there is no balance. They went to what they did in this law. I will also want a participant to look at the Charity Act of 2012 in the UK. They actually adopted most of the provisions of the Charity Act into they actually modified it to bring it to registration of incorporated trustees. But not all incorporated trustees are charities. That is the problem in which in some, there's been an argument that there should be a separate law for charities. We do not contribute money. We contribute money because of our faith, because of the movement we are carrying on, if it's for NGO, civil society. It is not for charity. So you cannot also go to the UK and bring their law and come, because in the UK, churches are not regulated by that same act. Even in the country in which they brought it, that law is not regulating churches. That's to show you that they actually respect the right to religion as well as freedom of association of those provisions of that law. CSC have a right that when you open an account as an association, for instance, if you open an NGO, open account today, it said one or more accounts. When you open a bank account, they should know what is in why you are opening the account. Dormant, they should be the one to inform CAC. And within, if not, CAC may. You see the problem that is causing? That, for instance, where people, profess their faith, you can dissolve it because they did not tell you about bank account. Do you know the number of cases we will have in court? You know the problems you are bringing to the Nigerian society that can be avoided. The money that is inside the account, if you can trace it, that is the proceeds of crime. Then we have laws on crime to hold the people who actually pass that money through that process. We have our laws of money laundering. We have the SCUM and all those declarations. Those are the ways to checkmate these things. Why is there particular attention on incorporated trustees? That is what I am also finding. Why would CSE, who did not contribute money to this account, have the powers to now dissolve the association? Not dissolve the account now. Dissolve where I profess my consciousness or where I profess my faith. Or for instance, I belong to a football club where we sit down, we play football and we are married. But because we did not, notify CAC, or the bank refused to notify CAC, you now come and dissolve it. You did not pay money for us to register it. You did not make contributions to us. Just because they've not declared, you now come and dissolve it, and our money is now taken to another association. That is why I told you, this is what operates in the Charities Act in 2012 in the UK. Now, charities are for charities. So if monies are not properly used for the charity, for the subject matter of the charity upon which it was made, it will now be taken to a similar charity. But that is not so for incorporated trustee. So there should be this is what part of the things we are advocating. Charities should be differentiated from incorporated trustee as far as it concerns NGOs, civil societies, as well as religious bodies, Islamic organizations, churches, and all those things. Because they are not charity, so to say. People may actually give gratuitous payment, but they are not charity. They are a way in which people profess their faith. So if you give powers to CAC to tamper with people in the way people profess their faith, it is a recipe for disaster. Because they give them so much in their own opinion, in which the court have that opinion is subjective. It's subjective. So that should not be. That should not be. We have our laws on money laundering. We have our laws to trace crime. We have the Economic and Financial Crimes Commission. We have ICPC. They know how if they can trace proceeds of crime to an account, they know what to do. But to say that because you want to, monitor accounts, you can dissolve where people practice their faith or practice their consciousness or their movement, I think it is the state actually coming too much into the bedroom of human beings, into the bedroom of persons. Yeah.
Powerful. Powerful and compelling as well. My takeaway from here is the distinction you drew between charities that are regulated in the UK and then religious bodies, how there is a difference in the regulations for these kinds of organizations. I recall sometime last year in the EU Act National Conference sponsored by British Council, I recall where a lot of CSOs gathered, and one of the bane of the discussion was that there needs to be a distinction between the different kinds of entities that are registered as trustees, so that everybody is not subject to the same kind of regulation and the same kind of monitoring, given the differences of the different associations and their different categories and classes, just like you try to draw a distinction between religious organizations and just NGOs that are formed strictly for charities and not religious organizations. Beautiful points there. I'll keep my question. Now, moving on to the interesting parts for me, very interesting, because this has to do with a compliance feature that causes defaulters to pay penalties where they've not complied with this provision. That's section 845. Yeah, before I go to section 845, I would like to address the audience. Don't forget that you can put in your questions in the chat box. You can put in your questions in the chat box so that we can take them as the discussion on the sections is going, or you can wait for the Q&A session. That's fine, either ways. So going to section 845. Section 845 talks about the need to file biannual returns in June of every year. We file biannual returns in June and in December. It's called a biannual statement of affairs, but we refer to it in the compliance balance as biannual returns. It requires incorporated trustees to file biannual returns every 6 months. And you see, failure to comply attracts a penalty for every day during which the default occurs. And then it also, there's section 846 that talks about association keeping necessary accounting records and all of this. And I'm wondering, okay, before the question, 8.7 talks about the duration the accounting record should be kept for, that it should be kept for at least a minimum of 6 years from the date they were made. And it also talked about the fact that If for it goes further to provide for the filing of annual returns. You know, CAMA 2020 introduced the biannual returns. Annual returns had been in place since last act we had, since 1990. The annual returns had been in place since. So yeah, here's my question. How does requiring incorporated trustees, how does, someone is asking, okay, I'll take that later. How does requiring incorporated trustees to file returns, how does this amount to a breach of your right, or a breach of the right? Let me not say your right, because the right you're talking about is not just your right, it's a right for everybody you're seeking to fight for, or you fought for. How does it affect the right to freedom of religion and association, considering the fact that the right to freedom of association is an unfettered right? You can choose to say, I want to form this association, or I want to belong to this religion and want to call ourselves this. CSC has no business with you. But the moment you choose to submit yourself to CSC for registration, to be a corporate body, to be known by a corporate name, you have to, there should be some semblance of you coming under the law of CSC and being accountable to CSC, so they know that, oh, we registered these people, this is what they have done, this is what they are doing, to keep abreast in case someone needs to conduct search at CSC for the organization that is registered with them. So how does this right, how does the fact that people who are choosing to submit to the registration of CSC would now not want to file returns to CSC to keep an account, or let CSC know what is going on with them? So how does these sections, these provisions that I just read, how does it translate to a breach of the fundamental right to religion, association, good conscience, and all of this? Please take it away, sir.
Of course, I agree with you to the extent that, you know, in a sane world, there should be some form of regulation. You know, your right is not absolute, because if it is done, if your right is absolute, it will affect the right of other people, as Section 45 of the Constitution actually provides, as well as, so I understand to the extent that, you know, it ought to be regulated in some form of way, but not over-regulated. That is my point. Now, Section 827 of the Companies and Allied Matters Act provides for a constitution that provides for all these things that is said in this section. Now, the members should be the one, for instance, CSC should have a framework upon which people should file, you know, their returns in CSC. Now, it will be contained in your constitution before they even register that association. That is a way, you know, to ensure that, you know, a proper thing is done. If they change, if they remove, it can be indicated in CSC, and that accounting is done. But coming heavy on them, the way they did now, that if you do not file by annual this, why do the account, is it for CSC or is for the members? Don't forget that it is the members that pay this money. CSC is all to know that this thing is a going concern. For incorporated trustee, all CSC have to know is that it's a going concern, not for you to know what we do with our money. That is the prerogative of the members. That is why I started on the background of Section 827, and as well as the fundamental rights in Section 38 and 40. It is for the benefit of members, and not because the way that provision is couched, it is couched as if it is for the benefit of CSC, that CSC want to find out something. No, it ought to be for the benefit of the members. So see, there should be a reasonable framework under Section 827 that provides for that constitution, in which the constitution will provide, you know, the time of the year they have to provide their annual returns, their accounting, they should be like a financial report. I understand, in which they ought to know that, okay, they are a going concern. And how do you know that something is a going concern? By, you know, effective certain filings at CSC, but not to go to know the nitty-gritty of an association that you are not a member. If you want to know what happens inside an association, apply and become a member, so that if monies are not used effectively, you can actually go to court. Because this is using too much state powers in this right. That is what I'm saying. They need to also monitor it, but not to come to have more powers than members of an association. because CSE is not a member of that association and just a body that registers it. Doesn't give it the power to now run it as if it's running businesses in Nigeria. And as the court said it, the court said, permit me to read. He said, asking association registered under the Act to make returns is almost like making them incorporated companies. The Companies and Allied Matters Act was made to regulate the affairs of companies due to the need to protect investor funds and encourage foreign investment in Nigeria. The association under incorporated trustees are not for-profit organizations bound by a common interest or belief. It is my opinion that they must not be overly burdened with too many restrictions and laws to fetter their liberty. Individuals under this association have a right to assemble freely and choose who lead them amongst themselves, and not for the commission to poke nose into their affairs. This is what we said at the, the court even went ahead. I don't think it is the position of it is the position of the members. Now, yes, it ought to be regulated, to some extent, in which they need to file something at CSE to show that they are a going concern. But not for you to come heavy on them and say they will pay penalty, that you dissolve them. No, it's coming too heavy on intellectual. So you cannot say, you can do that for businesses, but you cannot do that where people, and the kind of country we are, when it comes to the way where people actually just arguing football, people might actually kill them. You can know how we believe it. So these are dicey areas in which the state should tread with caution. Yes, that's what I think. So I believe these are dicey areas in which the state should tread with caution, because Nigeria is a secular country in which we must also respect that our secularism. That is what I think.
Okay, so again, my takeaway from this, you talked about the issue of prerogative being that of the members, not the commission, and then the issue of penalties. Yeah, the issue of penalties, that if they don't do this, you're slamming them with penalties. And so these people are not for profit. These people, religious organizations, why would they need to come and start paying penalties? Because they don't tell you what they're using their money to do and all of that. I get that. I have a question there, but I'll save it for the Q&A session. So I'm not the only one asking all the question. Please allow me to reiterate the ground rules. When you join in, please keep your mics muted, because sometimes when we have breaks in the speaker's mic, it's not because he's having a network issue or he's turning away from his mic. It's because someone unmuted. So please, let's all ensure that our mics are muted so that this discussion can go on seamlessly. Thank you for the cooperation. So moving forward to the next section that was struck out. Yes, so we stopped at, this is 847 and 848. The next one is 851, and I can totally understand that. Well, I'll just scroll down to it so that everybody can follow. I can see the comment, the chat section buzzing. It's good that it's buzzing. Okay, so this is the last section that was struck out, section 851. It's the section that gives the power, that gives the commission, the power to establish an administrative proceedings panel. It talks about the composition of the panel, and then the people it can co-opt. And it goes further to talk about the scope of the function of the panel. And this administrative committee will provide the opportunity of being heard for persons alleged to have contravened the provisions of the Act. That is the act that was passed for the commission. The commission will sit down, would have a panel to discuss issues concerning the contravention of the Act in an administrative proceeding, and then also impose administrative penalties. It's just like giving the commission power to resolve disputes regarding the breach of the provisions of CAMA 2020 and you challenged it. I'm not going to be asking you why did you challenge it, what is here to challenge it, because I think it's somewhat clear for all to see, but for the benefit of those who have not read the judgment. I know you mentioned this in your introduction, but there are some people that joined us long after you had finished the introduction and they missed out on this part. So please, just tell us your argument in respect of this section that the court agreed with you, the rationale the court adopted, and why the court struck out the provisions of this section 851 of CAMA 2020. You've been doing fantastic so far, sir. Thank you. Please take it away.
Thank you. On this point, issues that are important, they are germane not only to persons in Nigeria or citizens of Nigeria, but also most especially to Nigerian lawyers. Now, first of all, the two legal issues are the right to fair hearing, the right to access to court, the right to fair hearing, and the powers to usurp the powers of the court. I will take them briefly. Now, the right to access to court, it's a constitutional provision under section 6, sub 6b, that the judicial powers shall be vested in accordance with the foregoing of this section, shall extend to any persons between government and authority, to any persons in Nigeria, and to all actions and proceedings related thereto for the determination of question of their civil rights and obligations. Now, a third impartial person ought to hear it, not the government itself being a court, because he said to extend to persons and between government of authority and to any person. So the executive arm of government cannot be a court on its own, because we have a judicial arm of government. This is a constitutional issue. The Corporate Affairs Commission is under the executive arm of government. They cannot be the judiciary again. That is why the court carefully mentioned the legislative arm, mentioned the judicial arm, and mentioned the executive arm. So the Corporate Affairs Commission under the executive arm of government cannot establish a court on its own. That is for judicial powers. And section 36 of the Constitution actually says that every person will have a right every person shall have a right in determination of his civil rights, including any question against government or an authority, shall be entitled to fair hearing. So our argument is that we cannot get fair hearing there, because most of the matters that have to do with the corporate, CAMA, Companies and Allied Matters Act, have to do with the Corporate Affairs Commission as the main party or as the nominal party. So how do I get fair hearing when the person that will hear the matter in which I have a problem with will be the one to sit in judgment? And it's against natural justice and fair hearing that you will be a judge in your own case. That cannot work. And as long we also know that the courts too would jealously guard its jurisdiction. Now, section 251 of the Constitution, 2511E, the Constitution being the ground norm, have said any matters that come from Companies and Allied Matters Act or any other law that will replace the Companies and Allied Matters Act will go to the Federal High Court. And there are many cases on this matter. Now, I think it is an impunity, to say the least, for you to now make administrative, proceedings committee under section 851 to make the registrar of the Corporate Affairs Commission, directors of the Corporate Affairs Commission who did the mistake that you are complaining of, as well as director for the Ministry of Trade and Investment, to form an administrative proceedings committee. So on these three grounds, the court said, no, you cannot usurp the powers of the court. They said the court said in that case, it said this constitutional provision gives power to resolve dispute to the Federal High Court. That's section 251, section 851. Promptly grant these powers to the Administrative Proceedings Committee headed by the chairman of the Corporate Affairs Commission. The law is said that where a law is contrary to the provision of the Constitution, it will be void to the extent of its inconsistency. This is the fourth point. Any provision being inconsistent with the provision of the Constitution. Section 6, subsection 6 have already provided for judicial powers. Now, any other powers that is inconsistent to section 6.6 is inconsistent, null and void to the extent of its inconsistency. So the point we are making on that section 851 is, first of all, judicial powers of the court have been taken away, in which the court says, you know, there is a separation of power between the executive, the legislature, and the judiciary. The executive cannot sit in judgment because most of the matters that will be coming will arise out of, you know, actions or inactions of CAC. So why would they now sit in judgment as an administrative, you know, proceedings committee? That is one. Two, the right to fair hearing. Because the matter is against them, there is a likelihood that I will not get fair hearing. This is my insinuation. This is what I think. And it is human nature that you cannot be rational in your own case. This is the second point. So the third point is usurping the powers of the court, in which the Constitution have already provided in section 2511E of the Constitution of the Federal Republic of Nigeria as amended, that power belongs to the Federal High Court and not to any other court, not to the Court of Appeal, not to the Supreme Court, but to the Federal High Court. I think it is not proper for them to now make that, to take away, you know, that powers from the Federal High Court. And the court will jealously guide against it, anything that will take away jurisdiction. Then lastly, on the same point, any other law that runs in the face of the Constitution, under section 1, subsection 3 of the Constitution of the Federal Republic of Nigeria, that law is null and void to the extent of its inconsistency. It was upon that ground that the court held that the provisions, the court held in that case that this court will jealously guide its jurisdiction and will not allow any provision to oust its jurisdiction. It is the duty of courts of law to safeguard their jurisdiction. The court now went ahead to, you know, mention section 4, subsection 8 of the Constitution, subsection 8 of the Constitution, and concluded that the court will not allow the provisions of any statute to oust its jurisdiction conferred on it by the Constitution. Section 851 of the New Companies and Allied Matters Act fall under this category, and the court vehemently resists such ouster. Consequently, section 851 of the Companies and Allied Matters Act 2020 is hereby declared null and void for ousting the jurisdiction of this court and for being inconsistent with the provisions of the Constitution. So we're also glad that the court actually agreed with us on this point. But if you'll be asking us the point the court did not agree, maybe subsequently you can ask so that we'll also tell you what we think and what we've done.
Okay. Wow. I didn't get the last sentence you made.
I said the court agreed with us on this point, but there's a point the court did not agree with us. So okay. I said I would, you know, if you ask me going forward, I will tell you what I think about what the court said and what we've done about it.
Okay. So I'll ask you that. What very, very beautiful point. So you've highlighted the four bases, the four grounds upon which the court based its judgments to strike out this section. One is that the court must jealously guard its jurisdiction, and that is certain. The court guards its jurisdiction jealously. No one, nobody, no other court can usurp the jurisdiction of a court when it knows it has the jurisdiction in respect of a matter. Perfect. And the fact that you can't be a judge in your own court. I know when we used to do Latin maxims, that was Nemo Judex in Cosaswa. You can't be a judge in your own court. The issue of fair hearing and all of that. So, yeah, so right now, I'll be going into the chat box to look at the questions that have been placed there and the comments. I'll just be reading through some before I ask you that question that you hinted me to ask you. But at this point, I must say thank you very much for the passion with which you delivered this presentation. Like, it's evident, you can see that these are issues that are actually burning in your heart and in your head for the masses. So the first comment I'll be reading I should turn on my video now. Okay. So the first comment I'll be reading is from Dennis. It says, okay, coming from the CSO background, I think this conversation really needs to be taken to NGOs to understand what the judgment is and how it's, I don't know what is obstructing. And now it's something opening the shrinking space of civil society in Nigeria. How can we work together on this? Okay, how can we work together on taking this to the civil society space? That's your question. Okay. I'll go on to read the other questions that are more direct in this discussion. Then we'll come back to this question. And then, okay, someone is supporting this question. Sonny Wokoro is saying, I agree with you, but the NGOs are really active these days. But nonetheless, this definitely warrants a civil protest. What is warranting a civil protest? Is it the fact that the court has struck out the sections, or the fact that the sections were existing in the first place? You might need to clarify that so we know what we're protesting for. Okay. Someone is asking for the materials for this presentation, if it can be sent to Mr. Kingsley precisely, if it can be sent to individuals by email address. Mr. Speaker, sir, hope you wouldn't mind us sending the judgment to attendees.
No, send it to as many people that want it.
Okay, so we have his permission to share the judgments with you all. So we will do that. Okay, interesting. Mr. Francis is saying interesting public interest litigation. I hope the judgment is appealed against by the respondents. Speaking about that, your hope might just be reality, but we don't know yet because we reached out to the respondents and the respondents said that they're filing an appeal, or they filed an appeal, and so the matter is sub judice from their end. But however, our delectable speaker here confirmed to us that he has not received a notice of appeal, and so we decided to go on with this discourse. Okay, more people asking for the judgment, and I think that is it. I don't really see any question here anymore. Aside that, so I'll just go ahead to ask you the question that I didn't ask you. And you know, I had some questions from your presentation, but I'll ask you the question. What was the point that the court did not agree?
Okay. I'll say that quickly. Okay, before I say that, let me, respond to what Dennis said. That they should bring this discourse to the point of civil societies. Yes. Now, ordinarily, most of these things, we know about these laws, but, no consciousness, there's no activism on it. So I don't mind that anytime the NBA calls me or civil society or any form of association to actually speak on this matter, I don't mind actually speaking of giving materials, giving talks and all that. There should be a consciousness because the fundamental human right is not just one dead, it is actionable per se. Unlike other rights that you need to prove it, the fundamental right is actionable per se. Section 46 says, if your right has been, is, or is likely to. So you just suspecting that, the way Princess is looking at me, my right is infringed, is a cause of action. Of course, we will not be that ridiculous, but we need to protect our rights because the way rights are being infringed these days is because, there is no consciousness in which people will stand up for this thing. States have powers, people also have their rights. So there should be a balance between these two rights. So there should be, this discussion should continue so that there should be a consciousness among the Nigerian people. Now, to the point in which we did not agree with the court actually held that the judgment or our processes is incompetent against the first defendant, the National Assembly, because we did not file a pre-action notice. That is what the court said. But our argument in which, is that pre-action notice is not applicable to fundamental human rights matters. Section 46 of the Constitution that gives persons the right to commence an action if your right has been, is, or is likely to be contravened, did not make mention of any pre-action notice. Section 46(3) of the Constitution that made provision for the CJN to make rules for fundamental human rights enforcement did not also make provisions for pre-action notice when it comes to fundamental right matters. Even the human rights action actually says, you know, that the court will enforce fundamental rights and will not interpret the law in any way that will restrict, you know, the hearing of fundamental rights. And there are cases in the Court of Appeal that makes, you know, fundamental rights an exception to service of pre-action notice. So we believe, you know, that we do not agree to some extent in what the court said. So we actually filed a notice of appeal. We filed it on the 28th on that point of law, on that part of law, that because what we actually want is that this law should be binding on the National Assembly, so that when next they are making laws, they will compare the bills before them vis-a-vis the provision of Chapter 4 of the Constitution before they will make it to see the light of the day. It is their duty as the lawmaking body to know that the Constitution is protected, that the fundamental rights of citizens in Chapter 4 is protected. The only way for this to be done is not for this judgment to be said is not applicable to them. It's for the judgment to be binding on them. So we actually appealed against that judgment and we are compiling a record for the court to determine whether pre-action notice, well, there are a number of cases in which we cited in our notice of appeal, but we are actually asking the court to determine, to allow our appeal and to determine that pre-action notice, because come to think of it, somebody infringe on your right to, for instance, to life, you have to go and give the person 3 months notice. In such an instance, you'll be, you know, contending your matter from the grave. The law actually expects that as soon as somebody is infringing on your right, you should go to court immediately for the state to use its power to protect you, and not for you to give. So you saying they should give the National Assembly three months notice is that you are making the National Assembly to be more powerful than the fundamental human right. And nobody ought to be more powerful than the fundamental right enshrined in Chapter 4 of the Constitution.
Interesting point there. Interesting point there. I believe when this case goes upstairs, we'll also hear the Court of Appeal decision or thought in respect to this powerful argument that you have canvassed. So I'll go ahead to read some of the questions that are in the chat box. So first of all, I would like to recognize the presence of Mr. Bulus Asen, who used to be a former chairman, a dogged chairman, innovative chairman, delectable chairman of the branch as it then was. Welcome, sir. Thank you for joining us, for finding the time to join us today. Okay, so moving forward, I will just go ahead to read the questions. I see someone just joined us, a very active friend on LinkedIn, Mr. James Bakolo. Welcome, thank you for finding time to join us today as well. Okay, so let me go ahead to read the questions. This is from Akintayo Balogun. Meanwhile, for everyone asking for a copy of the judgment, just look at the chat box. We've uploaded the judgment to the chat box. You can download it from there. The judgment is right at your fingertips. It's staring in front of you. Just download it from the chat box. Okay, so Akintayo Balogun is saying, I believe the position of CSA with respect to the deleted sections of CAMA was motivated by the happenings/crisis in the Assemblies of God Church that had gotten to the peak, and CSA and the police were being dragged into the midst of the infighting in the church. My mind probably led to the inclusion of that section in CAMA. How do you think CSA should deal with a problem like that? So the question is, where there are internal scramblings, internal fightings in an association, a religious association, how would a problem like that be resolved? How do you deal with a problem like that? That's the first question. I'll go ahead to read the next question. If you can just note that question down, sir. The next question, Okay, it's from Habiba. And Habiba is saying, is there a reason why the matter was not instituted under the fundamental rights enforcement procedure? My colleague and I were discussing this yesterday, particularly in relation to local standard. Thank you. So this question, why was the matter not instituted under the fundamental rights enforcement procedure? Okay, and from Mr. Anayo is saying, thanks to Mr. Ekpenyong for your public interest. Okay, you're looking for the judgment. The judgment has been placed in the chat box. You can download it from the chat box. Just download the judgment from the chat box for everyone interested in the judgment. Okay, please download from the chat box. Download from the chat box. And I think that's about it for the questions that we have in the Q&A session. Then I'll ask the final question and we'll round this up. So 2 questions. Okay, you can't find it. I'll send the judgment again. So Mr. Speaker, did you get the questions?
Okay, how can CSC solve internal wranglings in the church?
Yes.
Or in an association?
Yes, sir.
Yes. Now, the first way of solving any problem, as we know, is by negotiation and negotiation and mediation. Now, that is why they have incorporated trustees. Incorporated trustees of most associations are people in which they look up to. Like, for instance, in my denomination, my Archbishop, I don't think I'm in a position to argue with him, no matter what he does. Now, that does not mean that in some other, faiths, there won't be internal wranglings. But the first way is usually negotiation and mediation. Now, I don't think CSC is in a better place or in a better position to solve their problem. CSC is just the body in which they were registered. So most time, even in the 1990 Act, there's usually a constitution in which the best place to settle any matter in which it's the court of law. That is what the constitution provides. Because the court of law, we believe, and in which I know, is an impartial platform in which you go and ventilate, your grievance. The respondent will ventilate their grievance, and the court will look at it as an unbiased umpire and give judgment. I don't think CSC have what it takes to sit in judgment or to make a binding decision that will bind factions of a denomination or a sect. So the best way is through negotiation, mediation, and for them to go to court. I don't know, there's this thing about Africans about going to court. They feel, you've taken a person to you've actually affected them. No, it should not be the case. Civil people, instead of fighting, instead of, killing each other, why not take it to an unbiased umpire to decide the case? I think that is the best way to go. I don't think CSC is the best place to go to settle this kind of problem. The second question is, now under the fundamental rules, how you commence a fundamental right matter? Yeah. Hello?
Yes, are you asking?
Yes, I said under the fundamental rights rules of 2009, how you commence a fundamental rights matter does not really matter. Yes, you can commence it in any of the ways. The main thing is that what is the crux of the matter? What is the crux of the matter? Is the crux of the matter enforcement of fundamental human rights? And the laws actually provides for interpretation of a provision of the constitution of a law. You commence by an originating summons. And the rules do not provide that for fundamental matters, you can commence it by origin, because we want for the court to interpret the provisions of section 38 and 40 of the Constitution, section 6, section 36, section 38, section 40, section 2511E, vis-a-vis the provisions of section 839 to 851, to see whether those rights in the companies and allied matters are infringe on the fundamental right. So the main thing is that what is the crux? Under the new rules, how you commence it doesn't matter. But what is the crux of the matter is what the court looks at. So, and under the fundamental right rules, that you can commence an action to defend not only yourself, but you can defend the right of other people, of a community, or even the entire public interest. And the law even says that local standing will not be a ground upon which the court will dismiss or strike out a fundamental right matter. So it was upon that premise that the court said, because one of the issues was that we are meddlesome interloper, that we are not a trustee, and that we are busybodies. But the court said no, that under the new rules, the fundamental rights rules of 2009, that local standing is not a way upon which, these matters will be struck out. And most importantly, because the Attorney General and Minister of Justice is supposed to, commence action for the defense of any provisions of the Constitution. Now, from the history of Nigeria since 1960 to today, there's no Attorney General that have commenced an action against the executive arm of government to enforce fundamental human rights. That was what was said in the case of Fawumi versus Akilu. Let me see whether I can see the citation. Before the end of the program, I'll tell you that since the history of Nigeria, the Supreme Court in that case says there have not been any case in which the Attorney General and Minister of Justice have commenced an action against the executive, the president, because he is a member of the cabinet. So this gives the citizens powers. In that judgment, the court gave citizens the right to commence an action for the interpretation or the enforcement of the provisions of the Constitution. So we are fortified on local standing on the rules of court. Section 46 says anybody whose right has been infringed or is likely to. So me, I'm saying that in that matter, I'm not saying that my right will be infringed. What I'm saying that making of that law has already infringed on my right. Because if CAC actually implement that law, it will actually take away the right completely. So you will not wait until the right is being taken away. If it is likely to be taken away, you have to commence an action. And I'm more fortified that it is a constitutional matter. And as a Nigerian citizen, I have a right for the interpretation of the Nigerian Constitution as well as the enforcement of rights under the Constitution. So on those two grounds, I'm fortified that I have local standing to commence the action in court, and in which the court agreed with.
Powerful answer there. For those who asked the questions, I hope you are clarified. You can just comment your clarification in the chat box. Okay, everybody is clarified. Okay, okay, Mr. Dennis, I hope you are clarified because your question was also answered. There's a name I see among the participants, Mr. Paul Obare. I don't know if that used to be my one-time very lovely lecturer. If he is the one. Mr. Obare, if you are the Mr. Obare, I'm sending special greetings and acknowledging your presence, thanking you for the lives you helped to transform in the Law School Yola campus.
He's actually my classmate too.
He is the one. Yeah. Oh, wow.
He was one of our high flyers in Zaria. Yeah.
Wow. Obviously. Wow. It's a pleasure to have you join us. It's been a very long time. Thank you for finding the time to join us and for coming to also chair our guest speaker today. Thank you so much. Okay, so then there are other questions in the chat box that I will just take. But before I take those questions, so now, in the absence of any appeal that you know of, in the absence of any other, someone lost audio, please join again, try to connect again. In the absence of any order to stay execution of this judgment, what is the fate of CSOs and NGOs right now? Because we're approaching June, and you know the law says 848 talks about filing biannual returns. Yeah, And they're supposed to do that before 30th of June, otherwise there's going to be a penalty. So as it is now, what is the fate of CSOs in regards to complying with that law? Are they required to comply, or are they required to hold on till this litigation reaches the Supreme Court and a decision is reached at that, if it gets there?
Yes, thank you for your question. And you know, under our constitutional democracy, now the legislature makes the law, the judiciary interprets the law, the executive executes the law. Now they made this law, the CAMA 2020, the legislature made the law, and the executive actually assented to it. Now it now lies under that hierarchy of separation of powers between the three arms of government. Now, it lies in the judiciary to interpret the law. And part of the interpretation of the law is that how legal is the law? Because there are illegal laws. So when the law has been put on a scale, it did not pass the test in the eyes of the judiciary, being represented by Justice Omotocho of the Federal High Court. So in the eyes of the law, as it stands today, those sections are null and void. And what that means in common parlance is that as if they never happened, as if they are not in the CAMA, as if we did not see it, as if it has been struck out, until an appellate court, by the principle of judicial precedence and the hierarchy of courts in Nigeria, until an appellate court make a contrary, decision. That is the law as it stands today. Now, CSE will be in contempt of court for them to apply that law to anybody, to any individual in Nigeria. They will be in contempt of court. So the right thing to do in such a circumstance, if they do not agree with the decision or the reasoning in that case, is for them to appeal to the Court of Appeal, but the Court of Appeal to also, look at it and determine whether they agree with the lower court, or in short, whether the whole section on incorporated trustee should actually be expunged. But as it stands as of today, the 19th day of May 2023, that law is not part of the Nigerian law. Those sections that were struck out are not part of the Nigerian law. That is how it stands as of today.
Okay, perfect. So I'll just go ahead to thank you for answering my question. I'm clear as to that now. Let me go ahead to read the views and contributions and questions we still have in the chat box. And this will be the last batch of reading I would undertake before we take our group photograph and then round up for the day. From Mr. James Obakolo, he says, my views and contributions regarding FBOs and the initial FRC 20 years maximum of NGOs/FBO trustee leadership was preempted by the lifetime leadership noticed by that of RCCG in Nigeria. The federal court too need be reminded that Act of Parliament remains statutory and shouldn't be striking out what is already passed as an act, like the CAMA 2020. Else, other acts that mandate MDAs can equally be struck out, like FRA 2017-18 or CBN Act and all that. Okay, so Kefas is saying, well, thank you, Mr. James, for your observation. Kefas is saying, well done for the insightful presentation. Indeed, well done. I join him to say well done. Could you please provide more clarity regarding the distinctive feature of a charity based on the current legal framework of CAMA? Are charities better registered as companies limited by guarantee, or would you recommend a new legislative framework for charities? And the final question I have is for, it's not the final question. It's not the final question, but let me just read them all so I know I'm not reading questions anymore. So Barbara is saying, in view of the fact that there's no perpetual injunction was granted in respect of this case to restrain CAC from further amending CAMA to bring in those sections or reenacting same sections, that how can we prevent CAC from repeating this sort of amendments in the future? That's one. And the last question I'll be reading is from Ulan. I hope I pronounced that well. Ulan is saying, so we are to hold on with the filing of the biannual returns. That's good to know because CAC are already imposing heavy penalties for NGOs. I know he has taken this question, and I hope you ask the question for effect, because from your concluding sentence, you say that's good to know. So it means he has answered your question. So you just have 2 questions, sir. Did you get the 2 questions?
Please, can you remind me just the one for CFAs, whether I believe it should be registered as a company limited by guarantee?
Yes, it's saying, so based on the current legal framework of CAMA, should charities be better registered as companies limited by guarantee, or would you recommend a new legislative framework for charities?
I actually believe that charities are closer to company limited by guarantee than incorporated trustee, because companies limited by guarantee is for a certain purpose, maybe for sport, culture, and all that, and the funds they get from their members is specific for that purpose. That sounds more like charity to me. And even if they want to wind down or they want to wind up, the money will be transferred to a similar charity. You see, that is completely different from incorporated trustee. Now, I actually believe there should be a specific law on charities, because charity is contributions. The states also, I agree that the state should also, if you come and meet me that you want to collect money for a certain purpose, it is only proper for the state to be able to ensure that reasonably what you collected the money for is the purpose you used it for. So I believe there should be another legislation on charities. It should be regulated. I don't have a problem with it. My only problem that I have is that you cannot equate, churches, Islamic organizations, and other faith organizations, NGOs, and civil society. You can't equate them to charities because they are actually different. Charity, the sole purpose is for charity, but the sole purpose for association most times is for us to, express ourselves, how we feel on our culture, how we feel on our faith, and how do we believe in God. It is completely different. Money contributed in those kind of places, my mind is not charity, so you cannot come and regulate it in the same way. So I think the aim of CAC is to regulate charities, but since charities are incorporated as incorporated, they did everything all together. I think the law should be able to, the National Assembly should be able to, differentiate, these different associations, which are very important in the life of the people, because we cannot all be dependent on government or do things the way government. We should have our own way of, since we do not, as long as you do not breach the law, you can express yourself. And we express ourselves through this association, through this religion, in which the state should have minimal interference with them. So I believe that charity there should be a separate legislation on charity, as it is in the UK.
Okay, so
yes. Then the second question. Yes. Somebody also asked that it is actually tampering or usurping the powers of the legislature by striking out the laws. That is not the position of Nigerian constitutional democracy. It is the job of the judiciary. It is the job of the judiciary to look at laws made. You cannot just go on a law-making spree because you have the powers to make it. If we check the sections, the section 4 that deals with the legislative arm of government, you say you make laws for the good governance and for the order of Nigeria. So it lies in the courts, because the court interprets the Constitution and any other laws. So it lies in the court to say, no, this law is not for the good of Nigeria. So it is not entering into, because even the laws that are being interpreted by the courts are made by the legislature. So there is a balance. They are together, but one checks the others. That's where checks and balances come. So the balance, they check on the legislative arm of government for them not to make any laws that is unconstitutional or that will lead to problem, is that the judiciary should also look at the kind of laws they are making. Do you understand? That is why you need the assent of the executive arm of government, of the president, if you make a law. So the law, there are instances in which the president will say this law is not good enough. They will either take it back or they will step it. That is part of the checks and balance. So the judiciary, in Nigerian constitutional democracy, we actually think the judiciary is actually subservient to executive. Executive is first, followed by legislature, followed by judiciary. That is not the aim in which the makers of that system of government made it. They are on the same par, in which for every appointment, for any making of the laws, the three parts must play a role. The legislature makes the law, executive signs it into law, then the judiciary will now interpret it to say this law is good enough or this law is not good enough. Because there is no law for the judiciary to act on except the one that the legislature makes. So the legislature or the judiciary should have said, okay, we'll not interpret the legislative law, we'll make our own law. No, you cannot say that. So the judiciary do not take over the powers of the legislature interpreting their laws. That is what they were made. They are a single government, but they have different rules. Thank you.
Okay, thank you so much for that clear, lucid explanation and straight. And then there's a final question, the one on perpetual injunction. Since there's no perpetual injunction, what prevents CSC from repeating these provisions of the law via an amendment or reenactment?
Well, in hindsight, maybe we should have asked for a perpetual injunction preventing them. But of course, we actually learn every day. So I actually see that. But again, the main thing in this discourse is for us, members of the civil society, as well as human rights activists, for us to be more alive to this, because the whole essence of the judiciary and the court system, as well as lawyers, is to protect this kind of rights. So it is for us to be more alive. For every law that the National Assembly makes, we must look at it to what extent, because they have a good intention. Even this law itself has very good intentions, but it is the applicability that will lead to problem. In short, CAMA has made my job easier. There's a single director now, there's a single shareholders, there is, you can do, your statutory meetings can be by Zoom like this, and we'll be in different parts of the world and we'll listen to each other. And, you can keep your records through, electronic means and all that. Beautiful legislation. But it is only when it comes to that, maybe because of, what is happening in Nigeria, in which, a couple of owners of association go on a frolic of their own and with monies contributed by members. But I believe it is the problem of the members to trace it and not the people. So to answer not CAC. So to answer the question quite simply, I would say we need to be proactive, in short, so that when they cannot bring this law again, because the court have actually said it's null and void. But even if they bring this kind of laws, we should be proactive enough to also still apply to court. This time with a perpetual injunction to restrain them from, bringing this kind of law. The people should be allowed to manage their religion how they want it to be, to manage their consciousness how they want it to be, to manage their culture how they want it to be. Now, and not for CSC. If CSC wants to control them, it should register as a member of that association and have the same right of members. That is what I think.
Okay, thank you. This is me giving you a round of applause for taking the time to answer all the questions and give a brilliant presentation. And I observed you didn't even, yes, you were just spewing out facts with passion and authorities. well done so much to our guest speaker. I see a lot of people in the chat box saying well done. Please help me say thank you, Mr. Emmanuel, in the chat box. Just if he has actually helped you presentation, please do well to say well done, Mr. Emmanuel. Do well to say thank you for the presentation. Just do well to talk about how you saw the presentation or how the presentation came across to you. Yes, someone is saying bravo. Uchena is saying bravo. Victor Oche is saying thank you. Yes, Sonny is saying well done, Diba. Thank you, Mr. Emmanuel, for this insightful presentation. Thank you, Joshima. You stayed with us from the beginning till now, and you've been very, very active. You all have been. Thank you so much. Thank you so much. I would encourage you to feel free to connect with the speaker on LinkedIn. He's on LinkedIn as Emmanuel Ekpenyong. If you just type his name on LinkedIn, you can search for his profile and feel free to connect with him because he's always posting updates, publications, and some of all these judgments that he gets from court in public interest matters and all of those. So feel free to follow him and connect with him on LinkedIn. Also feel free to connect with me on LinkedIn and tell me how my moderating skills for this webinar was on LinkedIn. Drop a note, drop a word of encouragement, just drop something. I would look forward to connecting with you. We've come to the point where we get to take a group photograph. For those who are ready for the group photograph, kindly turn on your videos, or if you don't want to turn on your videos and you already have a very nice profile picture, put it up. I'll be snapping the pictures now and I'll be sending it on the group chat so you can download it immediately. You look for yourself and download the one you appeared in to post on LinkedIn and say you attended this event and this and this and this were what you got from the event. Kudos to the speaker, kudos to the moderator, kudos to your organizers, MBA Guarantee Branch. So are we ready for our photo? Looking now, I'll have to remove the spotlight. So we can take the photograph. I will have to remove the spotlight. Okay. So there's no spotlight anymore. Okay, so I'll be snapping the pictures in batches, and I hope you don't run away because you don't know if I've snapped the one that you are in or not in. So I'll just go ahead to start. And remember, I said I'll be posting the pictures in the chat box. So let me get a full view of everybody. Okay. So here comes the first picture for the day. Oh, I was not even looking up, and every other person is looking up. Okay, I'll just go ahead. Okay. Capture and sending this first one. I'm going to the next one now. I see lawyers are cute too, and they are beautiful. Okay, the next photo. This batch, I don't think anybody has their video on here, but I'll send it anyways. Okay, so finally, now just say your cheese. Say your cheese now, because this is the final picture. You must look as good as possible. This can be your visa. You can use this to apply for visa anywhere you go, in any embassy. So I'm ready to capture now. Yeah. And this capture, and that's it. Thank you all for joining in today. Thank you so much for finding the time to join. Feel free to exit the webinar. The recording is going to be available. Don't forget to connect with us.
Thank you
so
very much.
Ika, for joining us. You can see the chat
Thank
box.
you,
Everybody,
yes.
thank you. Do enjoy your weekend. Have a
Thanks to our
wonderful.
guests.
Thank you. Thank you very much. Yes.
Okay, so the meeting is going to end now for everyone in 5.
Hope you want, Mama. You have done very well.
Listen, thank you. I'm grateful.
Yeah, thank
I
you
owe you
very
one
much.
bottle.
Okay, thank you. I'm grateful.
Thank
All right.
you. 5, 4, 3, 2, 1, and bye.